Good morning, this is John Lynch with another one of Lynch Solicitors COVID-19 talks. This morning I'd like to talk to you about bankruptcy. Now, I am involved in both bankruptcy and personal insolvency arrangements as I'm a qualified PIP and also a solicitor. The main difference between both of them is that one is a court-managed, public official managed system, which is the bankruptcy, and the other one is the personal insolvency arrangements, which are managed by personal insolvency practitioners. It equates to to an insolvency situation for a company where you have a creditors winding up and you might have a court petition winding up. The two of them are not dissimilar in a lot of ways. However, the one key difference between a personal insolvency arrangement and a bankruptcy is that you must investigate the possibility of a personal insolvency arrangement before you go down the bankruptcy route. And in fact, an affidavit or document has to be signed to that effect. The other key difference, or one of the other key differences between the two of them, is that in the case of a personal insolvency arrangement, the family home is one of the cornerstone principles in the legislation, where the personal insolvency arrangement is always framed in a way that has the objective of protecting the family home. The same principle doesn't apply in the case of bankruptcy, where, however, in that case, if the assignee wishes to sell the family home, he must get the consent of the High Court in order to do it. One of the differences between them, one of the key features of bankruptcy, or the key features of bankruptcy, is that first of all, it's a high court or a court process that deals with all debts, secured debts, personal loans, credit cards, business loans, and mortgages. The other thing is that most unsecured debts are written off in bankruptcy. In the case of bankruptcy, the ownership of all assets are transferred to the assignee in bankruptcy. Now, there is a provision that allows a transfer back after a period of 3 years to the bankrupt of the family home in certain circumstances. However, all other assets stay with the assignee in bankruptcy. And the interesting thing about that is that if assets are held jointly with someone else, for example, a spouse or a business partner, in those circumstances, the assignee steps into the shoes of the bankrupt on the title and would in fact go about registering their interest so that everybody knows that. The other scenario is that, and it's the family home, while you may not necessarily lose the family home, you can try and agree a schedule of repayments with the lender, and if you get the agreement of the lender and the assignee in bankruptcy, it may very well be that you can retain the family home, particularly in circumstances where there is no equity or value in the family home over and above the loan. So, for example, if you owe 150,000 just as a figure, and you have a mortgage which stands at, say, 200,000, in those circumstances there is no equity in the family home. Of course, you have to be careful that during the course of the bankruptcy that the value of the home doesn't go up and therefore put you in a position where there is equity. However, that's for another discussion. The length of a bankruptcy is the other significant factor that has changed over the last number of years. Whereas initially, however many years ago, 5-6 years ago, a bankruptcy would be never ending, and most bankrupts were bankrupt ad infinitum. In the recent past, it has reduced to a period of 12 years, period of 3 years, and now more recently a period of 1 year. That means that you can be in and out of the process within a period of 1 year. The one big highlighted exception to that, of course, is that if you don't cooperate with the assignee in bankruptcy, or if you don't make full disclosure in those circumstances, the bankruptcy can be extended and has been extended in quite a number of high-profile cases in the recent past. So the entire 1 year period is prefaced or underpinned by cooperation and full disclosure. The other thing to bear in mind, of course, is that if you have money over and above your reasonable living expenses, then that forms part of an income that's available to the assignee in bankruptcy for a period of 3 years to pay to the creditors. The point about that, of course, is that under the insolvency arrangement and under the bankruptcy arrangement scenario, there is a mechanism whereby you can calculate how much money equates to reasonable living expenses. This was established under the insolvency legislation, and there's a ready reckoner on the Insolvency Service of Ireland website that will enable you to calculate exactly what it is you can put in your pocket. So you can have a certain pocket money, is probably a very simplistic way of talking about it, but you can have a certain amount of income available to you for overheads, living expenses and that. And in addition to that, the assignee will also allow you a certain sum of money to pay rent and or to pay a mortgage. The other thing that you need to be aware of when you're dealing with bankruptcy, or that you should know, is that in a bankruptcy situation, you are officially on the register. So in other words, anybody can check the ISI registered, that's the Insolvency Service of Ireland website, and check to see who is or who is not a bankrupt. And so it's fully known to everybody, and it's published and available for anybody to see. The other thing, or the corollary to that, of course, is that for a period of 5 years, your credit is going to be affected under the credit bureau system, which is what the banks check in order to see whether or not you have or have not been made bankrupt, or not so much whether you've been made bankrupt, but that you haven't paid or repaid your loans. The other kind of baseline question that when you're dealing with bankruptcy is who's eligible for it. And the criterion is that if you're insolvent, then you can apply for a bankruptcy. There's a limit, a financial figure of 20,000 some odd that you must have owed, if you know what I mean. So in other words, if you're to do a sum on it, you divide what you owe from what you have. If there's a differential there of 20,000, then under those circumstances, you are insolvent. There's a lot of debate about exactly what insolvency is, but that's not something that we need to discuss or should discuss on this short video. The other thing, of course, is that, as I said previously, you must establish that you applied for a personal insolvency arrangement or a debt settlement arrangement before you go down the bankruptcy route. You must lodge money in court. There's a 200 fee or some odd payable to the bankruptcy division to apply for it. You must present a statement of affairs which set out your full financial position, and that must show, as I was saying, that your debts exceed your assets by more than 20,000. And then you prepare, in terms of the paperwork on it, then you prepare your petition for bankruptcy. Most of the paperwork is approved in advance by the examiner's office, who's the office that deals with bankruptcy. And once the paperwork is in order, by and large, that is the end of the matter in terms of making your application. The next step on from that, of course, is that once you've made your application for bankruptcy, you attend court on the day that the bankruptcy application is listed. Effectively, if the papers are in order, the judge will grant the bankruptcy. You connect with the Insolvency Service of Ireland, who manages the whole bankruptcy process, and you give them a statement of affairs and a statement of personal information. Usually there's contact then between you and the bankruptcy office during the course of the year that you're in the bankruptcy, and you have various obligations that you must comply with, the most obvious one being that you must make full disclosure, and that's where you complete your statement of affairs, and that you have to ensure is accurate. But in most bankruptcy scenarios, that's usually the end of the matter. unless there's a situation where there's clarification required by the assignee in bankruptcy's office. And then the next kind of connectivity that you'll have with them is to do with the family home, whether there's equity in it or not. And the thing to remember about the family home is that if the family home is in negative equity, it may very well be that in those circumstances, after 3 years, it comes back or it reverts back to you as bankrupt. As I said, all the other assets remain with the assignee in bankruptcy to deal with as he sees fit. The end of the process then is the income payment, what we call the income payment order, so that if at the end of the year the assignee in bankruptcy is satisfied that there's excess income over your reasonable living expenses, if there is an excess income available, they will look for what we call an income payment order, and you will pay that for a period of 3 years. Often a good idea is to anticipate that and make provision for it in your first year. In other words, get to it before they get to you, and have set aside that amount of money that you can make available to the assignee in bankruptcy. And on a final note, just as a general observation, and I will deal with family home subsequently, it's very important that you make full disclosure to the assignee in bankruptcy. It's also very important that you bear in mind that you can negotiate on the family home. It's also important to realise that you can have a bank account, but there's a limit to the credit that you can have. You can have a job and can continue to work that job. You have to be careful, of course, that if there's certain professional restrictions on the job in a bankruptcy situation, that you're aware of those and that you notify and deal with your employer. The only other point that I would make is that when you come out of the bankruptcy and you're finished with the bankruptcy, the creditors aren't entitled to engage with you while you're in bankruptcy, and neither are they entitled to come back to you after the bankruptcy. Once you've put the debt into bankruptcy and it's wiped, after that, that should be the end of the matter.